As outlined with our agenda, we have a search and seizure presentation, police encounters with citizens, and give us a minute to sort of reshuffle ourselves.
Good evening. My name is Gordon Friedman. I'm a member of the commission, and I am the chairman of the Police Encounters Committee. And we are anticipating the city's policy vis-a-vis the consent decree and the demands of the consent decree. So in doing that, in anticipation of that, we have drafted basically what is in effect a citizen's guide to police encounters, all which comes under the Fourth Amendment. Bethany Studenic has done a remarkable job putting together various inputs from myself and others, including members of the academic legal community, ACLU, et cetera, in this presentation. I will answer questions arising out of this presentation when Bethany has concluded. You do have on your seats definitions regarding search and seizure, or as I'd rather call it, police encounters, citizen encounters with law enforcement. And with that, let me introduce Bethany Studenic.
Hello, everyone. So as Commissioner Friedman talked about, we're going to be talking about police encounters. Our goal here is to help community members understand a bit more of the language that we're expecting to see and some of the general outlines of the law around police encounters. So we're going to cover police encounters and searches. Under police encounters, we're going to talk about voluntary contacts, investigatory stops, and arrests. And under searches, we're going to talk about pat-downs and frisks, consent searches, custodial searches, and searching a car. We're going to try and keep this under about 20 minutes, and then Commissioner Friedman is going to take questions. So we're going to start with the Fourth Amendment, and this is where we get our protection from unreasonable searches and seizures from the Constitution. And what it says is that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The important word here is unreasonable. We're going to see that word come up quite a few times. So to start out, what is a search? A search is when the police or another governmental entity searches a person, a dwelling, a car, or another area where you have a reasonable expectation of privacy. A seizure is the holding or taking of property or person by a governmental entity. The consent decree defines a seizure in paragraph 453, and it says that a seizure occurs when an officer's words or actions convey to a reasonable person that they are not free to leave. So that means an officer has to say or do something that a community member feels indicates that they're not free to leave that conversation. Something to think about whenever we're looking at policy is that the Constitution provides the minimum standard by which police departments have to operate. They are free to do additional things. They're free to have additional policies and restrictions that they place upon themselves. So it's something to think about when we're looking at policy. A police chief in Kalamazoo, Michigan talked about that a little bit, about a traffic stop as a tool. So what he said is that the traffic stop is a tool that we have in our toolbox, but is it the best way to approach crime in our city? To go out in any neighborhood and make an abundant number of stops in an effort to find drugs or weapons, we've rethought that idea. Is it the most effective approach? Is it the most efficient approach? There's nothing constitutionally that restricts an officer from asking, "Mind if I search your pockets?" However, is it legitimate? Is it something we should be doing? You have to have a lot more reasons than, I can do it, so I'm going to do it. That's kind of how we're going to think about policy a bit. So something else to consider when we're looking at policy is the interests of the different groups that are affected by that policy. When we're looking at something like search and seizure, we need to think about both the police's perspective and community members' perspective and rights. So from the police's perspective, they've been charged with the responsibility to protect citizens. They need the ability to question the public and get answers whenever they're conducting an investigation. They are often required to enter dangerous and volatile situations, and officer safety is a paramount concern. However, on the community side, we have an interest in a protection of our individual rights. We need the ability to contact police when they're needed and to trust that police are going to respect those rights. We deserve the enjoyment of a safe community, our communities. And we have an interest in the preservation of dignity, freedom from frivolous questioning or intrusion into personal spaces, those constitutional protections. So when we talk about seizures, we're going to talk about voluntary contacts, Terry stops, and arrests, and that's going from least severe to most severe in interactions with police. So we're going to start with voluntary contact. Voluntary contacts, we want to bring two potential options in a voluntary contact to your attention. So there's consensual encounters and there's non-custodial interviews. The hallmark of a voluntary contact is that it is voluntary. A community member can leave at any time. Now, a consensual encounter is whenever you're talking to a police officer about something unrelated to an investigation. So you're talking about the weather, you're talking about your community, you're talking about your day. A non-custodial interview, you may be talking about an investigation, but you're not under arrest. So, and you're not being held, you're not being seized. You're allowed to walk away at any point. So encounters like these, they're not seizures under the law, but they can rise to be a seizure. And that happens, like in the consent decree, whenever it talks about it, whenever a community member feels that they aren't able to leave because of something an officer says or does. It's important to note that it can be kind of hard to define and recognize for both police officers and community members whenever that line is crossed. We're going to move on to Terry stops or investigatory stops. So investigatory stops are, they are based on reasonable suspicion, and that's in your handout as well, the definition that we'll be talking about. Reasonable suspicion is a belief based on operative facts that a crime may have occurred. Reasonable suspicion is more than a hunch, but it's less than probable cause, and we're going to talk about probable cause in a few minutes here. It takes into consideration all of the facts and circumstances in that individual circumstance, in that situation, as well as the officer's experience and training and everything that's going on. Reasonable suspicion can't be based on race, ethnicity, gender, unless those characteristics are part of a specific and reliable description of a suspect. So an officer can briefly detain a person or vehicle if they have that reasonable suspicion that we're talking about. And that's the belief based on operative facts that a crime may have occurred. Along with that stop, an officer has a right to complete a minimally invasive pat-down, and we're going to talk about searches a little bit down the line. Something to look at is what other police departments are doing. So in Tucson, officers are not only required to meet that reasonable suspicion standard, but they're also required to say what specific crime they believe may have been committed. So whenever we're looking at policy, we can look at what other departments are doing and what additional rules they're putting around these types of issues. So whenever you're the subject of a Terry stop, there's no hard and fast rule of when you're allowed to leave. It all, again, is based on the circumstances and the situation. However, the officer does have a duty to let you go in as quickly as is reasonable. So there's that key operative word again, reasonable. So we're going to move on to arrest. An officer can make an arrest in one of two circumstances, when they have probable cause or when they have a warrant. Probable cause, like we talked about that we were going to talk about ahead of time, was a well-founded belief based on specific objective facts and circumstances that a crime has been, will be, or is being committed. So the standard is more demanding than reasonable suspicion for a Terry stop. A warrant is a document that's signed by a judge that says police can make an arrest because they have established that probable cause. Police get a warrant by making sworn statements that the judge considers that are usually in the form of an affidavit that are signed by the investigating officer. Whenever officers make an arrest and they want to interrogate someone, they have to provide a Miranda warning. A Miranda warning tells a person about their rights, and you may be familiar with what's included in it. It includes the right to remain silent, that anything said can be used against you, your right to an attorney, and your right to an attorney even if you can't afford one. So we're going to move on to searches. We're going to talk about pat-downs and frisks, consent searches, searches incident to arrest, and searching a car. So officers can pat down or frisk a detained individual, someone that's been stopped in accordance with the Terry stop and that reasonable suspicion standard. They can make a search over the outer clothing if they have reasonable suspicion that that person is armed. And this, again, is to protect officer safety. The searches must be minimally intrusive. However, an officer can remove items that they believe are related to drugs if they can plainly feel those items during that pat-down. Some communities have expressed an overuse of pat-downs and frisks in minority communities, and that's a consideration we need to take into account whenever we're looking at policy. Moving on to consent searches, during any encounter, an officer can ask for permission to search you or your effects or your car. You have the right to refuse consent. However, a lot of community members express that in practice they don't feel that they can refuse consent. Some communities express concern that consent searches, again, are used more in minority communities. So some examples of what other police departments have done and what policies they have to reduce the use of consent searches include requiring officers to get written acknowledgement of that consent, reminding officers that overusing consent searches can negatively impact their relationship with the community, and requiring officers to get permission from a supervisor to do a search. Moving on to custodial searches. Under the law, an officer can, as part of an arrest, search an arrestee's person and the area within their immediate control, and that again is to protect officer safety. We should consider when we're looking at really any of these searches, we should think about vulnerable populations or populations with special considerations. And that includes LGBTQ concerns, religious restrictions, individuals with disabilities, and individuals with language barriers, among many others. How do we want searches conducted for populations with special considerations? Finally, when can an officer search your car? They can search your car when they have that probable cause. And remember, that is a reasonable belief that a crime has been, is being, or will be committed. If they ask to search your car, you still have the right to refuse consent, but if they have that probable cause, they're still able to search your car. Additionally, an officer can make a limited search of areas within reaching distance during a stop if they have that lower standard of reasonable suspicion that a weapon is located there. So you're seeing, again, those considerations that are built into the law to protect officer safety. So for example, if you're removed from your car and placed in a police car, consider yourself under arrest. They've taken an affirmative action to demonstrate to you that you're not free to leave. So that would be a seizure. So we've covered a lot. We've talked about voluntary contacts, including those consensual encounters and those non-custodial interviews. And we've talked about investigatory or Terry stops. We've talked about arrests. We've talked about different searches, including those pat-downs, consent searches, searches incident to arrest, and searching an automobile. And we've learned about some definitions, including reasonable suspicion, probable cause, what a warrant is, and looked at some policies from other police departments. So whenever we look at the policy together, we should think about what should go into a policy to make sure that police are conducting these searches and seizures according to the rules that are placed based on our conversations. How should those policies be built to ensure that community members are being treated fairly? How will we know that police are following the rules? What would you need to see to know that this is something that has actually happened on the street? Would you need to see data? Would you need to see statistics? Would you need to see it yourself, experience it yourself? How would you know? How should these policies guide police to do their job effectively and also safely? We have to think about how we protect officer safety. Is there anything missing from these policies? Is there anything that should be changed? So from your unique experience and perspective, are there any holes? Is there anything that you can say from your own wisdom that could be changed or could be improved? We'd like to hear about it. So I'm going to turn it over to Commissioner Friedman to answer any questions.
Great job, thanks. Any questions? Fairly complex area. Yes.
Okay, pretty much I know maybe with some of this information, the question I'm going to ask might be working in the profession as a private investigator. But going back to what she was saying in one of the segments, where a lot of people don't know that they can refuse for them to search your car. If you say no, they're going to say resisting arrest. And I've seen that happen on a lot of our clients. When they say, well, no, you can't search my car. Well, step out, you're under arrest.
Well, listen to what Nancy Reagan said, just say no. I mean, that's what I have to advise you. You have a right to say no. If you haven't violated a traffic offense and the police stop you, which may or may not happen, and they say, you know, would you step out? I would step out. I would cooperate. Consider yourself under arrest. If they search your car, make sure you know what's happening and what they take from your car. You're clearly under arrest if you're placed in another police car. The police may want to search your glove compartment. You know, the only thing you can do when you're in a vehicle is watch what's happening and report it to, hopefully, a lawyer as soon as you get one.
Well, this is my question. See, this is where it's tricky, and that's why I'm asking.
It's very tricky.
It's very tricky.
And it's your word versus the police officer.
Exactly, and this is why I get into, because if they pull you over for whatever reason, especially in a black neighborhood, for whatever reason, they're gonna make a reason, okay? And you say, well, I don't want you searching my vehicle. And then, now you're resisting arrest. They're gonna say you're resisting arrest. So it says there in black and white, and it says it in the law, so it's a trickle effect. You say no, you're an attorney, you're telling a client, no, you don't have to do that. But then when they feel that they don't.
If they tell you to get out of the car, you get out of the car. You do what they tell you to do. You don't resist arrest. Don't give them an opportunity to really arrest you. It's difficult. You're right. It happens all the time. I absolutely happens in the minority community. I had a client who played basketball for the Cavaliers. He was rather famous at the time. He was driving with his agent through the city on the west side. He was black. His agent was white. They stopped the car for no reason. Black man driving a fancy car. Get out of the car. And then they found out his name was Ron Harper, and he wasn't a bad basketball player, and they let him go. But they had no reason to stop him other than the fact he was driving a fancy car and he was black. Sorry? Yeah, I think things have changed a bit, and I think I think law enforcement's doing it a lot smarter, but that's the way it used to be. Yeah. First row.
2 questions. Are we talking about this because new search and seizure policies are CPC?
We hope so.
And in Tucson, being able to articulate a specific crime, does that go into a report later? Or
It's something that we can recommend in our report.
My question is that something the officer articulates in a report after this happens, or in person to person's home?
Articulate in his report after it happens. Yeah. Anyone? Yes.
What happened to the officer who pulled over Ron Harper?
Nothing at all. They
Okay,
just.
how is that going to change?
It will not change.
Because, okay.
So then why are we here?
Yeah, let's go.
But the only
can stop right now.
the only thing that I could say that it would change today, it would seem to me that officer is going to have to write a report, and he's going to have to give a reason why he stopped him. So that's going to be documented. In the past, it was not documented.
I think we're lacking an or else here.
Sorry, what?
The Constitution doesn't have an or else clause in it, but it really needs one. And that
Let's
is
rewrite it.
exactly. And I think we need an or else in these policies and in the laws.
Okay, I mean, that's fair enough. Anybody else? Gary?
Yeah, the police union, the Cleveland Police Patrolmen's Association, history of the CPPA about us page reads, in part, on July 23rd, 1968, in the Glenville section of the city, rioting militants murdered 3 of our own and a 4th officer died later. Do you find language like this consistent with unbiased search and seizure?
Not particularly.
But it still exists today.
I'm answering questions about search and seizure. And that's not a question, that's a statement. So if you have a question, yes, ma'am.
What is the difference between search and seizure and detention? Because it just seems
Well, a seizure is a detention. So if you're seized, you're being detained.
okay, the problem I have with the word seizure is being applied to human beings instead of my car, my
Seizures can be of human beings, cars, pocketbooks, jackets, and illegal things such as guns and drugs. All of that can be seized.
It just sounds to me that there's a dehumanizing that's occurring with the language that lawyers would like to use.
Well, you know, we use it.
Seems to me-
It is.
Can I
It
finish?
is.
Thank you. It appears to me that the language that is being used and applied to the public is dehumanizing the public. So as a lawyer or as a law enforcement officer, when you say the word seizure, it appears that you are talking about a car, something materialistic and not a human being. Seizure you apply to a human being usually applies to historically chattel.
You're absolutely right. And that's what the Fourth Amendment was about. The Fourth Amendment was originally, when written, was about slavery. And it was about being able to seize your slaves. So you're absolutely right about that.
So I think that
I totally agree with that, but that's from a historic standpoint.
but it hasn't changed.
It's not changed, and it's still written into the Constitution. You're right. I don't disagree.
What happens when a family calls 911 about an individual in crisis and the police arrive, they talk to him, they're not a danger to themselves or others, but they convince them to voluntarily go to the hospital, and then they change their mind? Can the police, if they don't meet the criteria to be pink-slipped, can the police still force them to go to the hospital?
No, not if they're pink slip. They should just walk out. They have a right to walk out.
So they shouldn't try to force them in the car if they
Nope.
change their mind?
Nope.
Okay, that's what I thought.
Nope.
Thank you.
Yep. Anybody else? It is a confusing area, and it's an area where you should basically go along with the police as long as you know what you're doing and what you say, but you don't have to allow police officers to search your car. And what they'll do is they'll keep you there for a while. They'll probably bring a puppy dog out to do a little circle dance around your car to see if their drugs are there. And the only thing you can do is just keep a mental note of what's going on so that you can report it in the future. And the officer is going to have to make a report, and he's going to have to write it down, which your lawyer will get if it's appropriate. Yeah.
Does the Cleveland Division of Police have database systems that will take these kinds of reports right now?
I have no idea. I would hope so. But I can't answer that. I don't know what they have and what they don't have. But, you know, what can I say? Yep, behind you.
Has the division's use of body cameras changed the search and seizure or problems you've seen or cases?
I think the answer is yes. I think there's more evidence to challenge whether or not somebody's lawfully arrested. So I think that, and body camera film is available through discovery by lawyers, and they can challenge a search and seizure or an arrest a lot more graphically than they could in the past, where it was the police officer's word versus the arrested person's word. Now you've got something that you can look at. So the answer is yes. Yeah.
My scenario is just a little different. So in the case of a homicide, where the actual homicide occurred in an apartment, it had nothing to do with the car, but the car was still searched, and it was searched without a warrant.
Not a good thing. It should have been searched with a warrant.
Correct.
Unless it was considered to be evidence of, criminal evidence or something like that, which may have been what was used to cover it, but they should have gotten a warrant, searched the car if it was involved in a homicide.
But it was not.
Yeah, it was an illegal search.
Yeah.
But who has standing to challenge it? The owner of the car. Was the owner of the car deceased?
No, I'm the owner of the car.
Then you had authority to challenge what they took from that car. Yep. Anybody else? Okay, well, we appreciate your questions. They're good ones. Some of the answers were not as good as some of the questions. But I think that you all have a definition sheet that should be helpful. And Bethany did an outstanding job just to give you a basis of this whole area, which is pretty complex. There's a lot of litigation going on about it, has been for a long time, and will continue to go on for a long time. Thanks.
Thank you.
And it's all about the Fourth Amendment and the right to privacy. Keep that in mind.
Well, thank you. And we'll keep these educational sections as part of our monthly meetings.